Bienvenue à la réunion numéro 37 du Comité permanent des langues officielles de la Chambre des communes. Conformément à l'ordre de renvoi du lundi 30 mai 2022, le comité reprend l'examen du projet de loi.
Committee is resuming its study of Bill C-13, an act to amend the Official Languages Act to enact the French language use by private enterprises under Federal Jurisdiction Act and to make related amendments to other acts. Today's meeting is being held in a hybrid format in accordance with the Order of the House adopted on Thursday, June 23, 2022. Members may participate in person or with the Zoom app. To ensure the meeting runs smoothly, I would like to pass along some instructions to witnesses and members. Before you speak, please wait for me to call your name. If you are participating via video conference, click on the microphone icon to activate your microphone. Please mute yourself when you are not speaking. Regarding interpretation, for those on Zoom, you have a choice at the bottom of your screen between floor English or French. For those who are in the room, you can use the earpiece and choose the desired channel. I remind you that all comments from members and witnesses should be directed to the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise your hand function. The clerk of the committee and I will do our best to keep the speaking order, and we thank you for your patience and understanding in this regard. As per our routine motion, I would like to inform the committee that all witnesses have completed the required login tests prior to the meeting. I would now like to welcome our witnesses. Appearing as an individual, the Honorable Michel Bastarache, lawyer and retired judge from the Supreme Court of Canada. Always a pleasure to have you among us. We also have the Parliamentary Budget Officer, Yves Giroux, Parliamentary Budget Officer, accompanied by Katerina Mikhalishin, his analyst. So 5 minutes each, which I will be very strict about, to give us your speaking notes. If you don't have enough time during the 5 minutes to say everything you've had to say, you will have the opportunity to elaborate during the question period. So we will start with Master Bastarache, Maître Bastarache. The floor is yours for 5 minutes. Thank you. First, I would like to highlight that we've had many consultations before the bill was drafted, and I think the government took into account the concerns of those who spoke on the issue. We had an opportunity to respond to the white paper and then to the bill itself. A Commons Committee and a Senate Committee heard a lot of representation and took note of the amendments that were suggested. I believe that the government is well aware of what Canadians think of the bill and should move as quickly as possible to pass it. I believe that you can always say that anything can be approved, but you can't satisfy everyone. We have a bill that will dramatically improve the situation of official languages in Canada, and we should only deal with the really critical issues today. I am all the more convinced that this is the right approach because I have long noted that the problems with the implementation of the Act, rather than its content, have been the main reason for calling for its modernization. While many believe that Heritage Canada has not been effective in exercising that required oversight, it is not clear that the problem is structural. I believe that the Department of Justice has not made adequate representations about the purpose and scope of Part 7 of the Act, but it is clear that the responsibility it had cannot be devolved to another entity. There needs to be clear policy, clear mandates, strict oversight, and rapid intervention when there is slippage. All agencies have a duty of competence and efficiency. It is Part 7 has had difficulty finding its place under the current Act. It is essential that the new Act allow this part to play its role. The Commissioner of Official Languages has already published a text interpreting it and explaining how it is to be applied. The Federal Appeals Court also has made a decision on it. The Department of Justice was wrong to reject this view and to propose to the courts a restrictive interpretation that renders the Act ineffective. The Minister of Canadian Heritage must use federal-provincial agreements to enhance the vitality of official language minority communities. In particular, he must verify how the funds paid out are actually used. Adopting policies is not enough. It is necessary to specify how the objectives are to be achieved. It is also important to specify that the government must not take steps backwards. Any measure that would have a negative impact should be studied and revised if it is not justified. One last thing. I find it illogical to give federal companies in Quebec the choice of being subject to Quebec's language law rather than the federal law. First of all, the two linguistic regimes have neither the same basis nor the same objective. At the federal level, bilingualism is imposed and supported, and the equality of the official languages is sought. In Quebec, there is only one official language, and a tolerance for English that originates in constitutional law. The goal is accommodation and non-discrimination, not equality. Second, I do not see how we can equate the role of the Commissioner of Official Languages with that of the Office de la Langue Française, nor can we create rights for citizens and workers that differ according to the will of the companies. If the federal government wants to intervene in this sector of activity, it should do so without intermingling politics and law. Thank you, Maître Bastarache. For the next 5 minutes, the PBO, so Mr. Giroux. Good morning. Bonjour.
We are pleased to be here to present the findings of our report entitled Cost Estimate for Bill C-13, an Act for the Substantive Equality of Canada's Official Languages, which we were honored to prepare at the request of the Standing Senate Committee on Official Languages. With me today, I have one of our lead analysts on the report, Katarina Michalishin. Je vais maintenant continuer mes remarques en français. Parmi les nombreuses dispositions du projet de loi C-13,
of the many provisions set out in Bill C-13, financial implications arise mainly from the proposed extensions of French language rights to federally regulated private businesses. We expect private compliance costs to implement these rights to be $240 million in one-time costs, plus $20 million each year in ongoing costs. These costs arise primarily from language training and bilingualism, wage premiums for managers in designated bilingual regions outside Quebec. The 2021-2022 Fall Economic Statement allocated $16 million for initial implementation costs for federal departments and agencies. This amount does not cover ongoing administrative costs and was not intended to cover those costs. However, it will allow additional initial implementation activities to be undertaken. We requested details regarding how the money is currently being spent. Despite a lack of cooperation from the responsible departments, we estimate federal administration costs to implement these rights to rise to $2.9 million per year. However, the amount of funding provided is fundamentally discretionary. The activities that can be undertaken in support of the implementation of Bill C-13 will be limited by the funding available. Katerina and I will be pleased to respond to any questions you may have regarding this report or other PBO work. Thank you. Thank you very much, Mr. Giroux. Did I understand correctly that that Ms. Catalici will add something? No. So first round of questions. We will start with 6 minutes for each political party. So first chair, Mr. Godin, the floor is yours for 6 minutes. Thank you to everyone for being here today. We are limited in time, so I don't want to be disrespectful to Mr. Bastarache or Mr. Giroux or Ms. Michalichin, but I just want to have short answers as much as possible. My first question is for the PBO. You mentioned that you have done some studies and there were some results. Despite the lack of collaboration from certain departments. Who are you talking about? Heritage Canada, Treasury Board, and the third is Immigration and Citizenship. Since you are a parliamentary officer, in what way do those departments have the right to not respond to you? Is there a certain mechanism in your role that allows you to force an answer? Indeed, according to the law, I have a right to the information that is under federal control. There are some exceptions, for example, personal fiscal information, cabinet deliberations, and deliberations regarding to the privilege between client and lawyer. And also there are certain things. I was told that this information was not public, which is not a sufficient enough reason for me to not have access it. So if I'm correct in my interpretation, which is that they just gave you some vague answer, how did you interpret those answers? Well, first, I thought that it was quite generous because it felt like a misunderstanding of the mission of the Bureau, because afterwards, the departments changed their minds once it was published, and that allowed us to estimate the costs that will be incurred by those departments. But the report had already been published, which would not have changed our estimates significantly. Mr. Giroux, do you think that demonstrates the lack of seriousness, the division of tasks and so on, when they don't want to give out information about Canadians' money and public funds? Do you think that this is ill-willed on the department's behalf? It could be, but it could also be a misunderstanding of the PBO's mission and our right to access, which is protected and is enshrined in law. The ministers might be better placed to explain why they refused. Next question is for Maître Bastarache. You said that the Justice Minister, and I will say this in my own words, but correct me if I'm wrong. You mentioned that they didn't do their representations correctly. And you mentioned their competence, which I would dare say was not up to snuff and was not at the and was not what should have been to apply the Official Languages Act. It demonstrates that there is some sort of confusion, no matter which party is in the House. There's a certain division, and who can tell the minister that there is a certain obligation?
Yeah.
The real problem is that the Department of Justice and Heritage Canada in particular don't have the same interpretation of the legislation, and they haven't had the same objective either. The Department of Justice intervened twice before the courts to argue for an extremely limited interpretation of Part 7, saying that programs could be abolished that were supposed to develop and encourage the vitality of official language minority groups. Even though there are other programs. I'm sorry, Mr. Bastarache, your answer is satisfactory for me right now, but I have another question for you. You mentioned that Heritage Canada has to indicate how the objectives will be fulfilled. And so under the legislation, the department has to indicate how it is going to either stop the decline, maintain, or increase. No, that is not in the legislation. It would be in the regulations. Mr. Bastarache, you know that regulations are discretionary and depend on people's goodwill. Thank you, Mr. Godin. Next question for 6 minutes for Patricia Lattanzio. You have 6 minutes.
Start first by saying what a pleasure and what a privilege it is to have the Honourable Justice Bastarache with us today, and I will address my questions to you. As you know, Honourable Justice, Bill C-13 references to the Charter of the French language in 3 different places, including the preamble. How do these references to the Quebec legislation violate the constitutional rights of the official language minority, the Anglophone community in Quebec, for it to fulfill the purpose and the spirit of Bill C-13?
Well, I think there is no real need to refer to any provincial legislation when we're talking about the objectives of a federal act. And in this case, it's illogical because the act in Quebec favors one single common language for Quebecers and accommodates the rights of Anglophones, which are mostly directed by the fact that the Constitution of Canada creates constitutional rights for Anglophones. So why would we ask the Office de la langue française to interpret the act or interpret any kind of action as being favorable or unfavorable to the minority when its object is not bilingualism and is not equality of both languages?
Thank you. So you also see then a conflict between l'Office de la langue française, the role, and the role of the Commissioner of Official Languages, do you not?
Yes, absolutely.
Okay. With regards to, you know that this bill also proposes that we ensure that Supreme Court justices are bilingual. As you know, many Canadians don't have the opportunity to plead their cases and bring them all the way up to the Supreme Court of Canada. So I wanted to hear your opinion with regards to justices at a lower tribunal, for example, the Court of Appeal. I wanted to have your input and take on how you see things of justices at the appellate courts.
Well, there's already an obligation in the lower federal courts because there were amendments in 1988 which provided that the litigants had the right to be heard directly by the judges that are sitting there. So they can address the court in their language, but they must be heard directly, not through translation. And that was a very important amendment in that time.
Taking back in terms of the role of ensuring that the law be respected, how would you see the role of the commissioner? Do you think that we would have maybe perhaps a tribunal for official languages, just like we have for the Human Rights Tribunal, or do you see it more, solely on the mandate of the Commissioner of Official Languages?
Well, I think the creation of a tribunal was already discussed and rejected many years ago. It was suggested at this time that we might look at that possibility again. But in fact, a lot of people are afraid that would add to the cost of litigation and create also more delays. What happens now is not adequate, especially because the commissioner only makes recommendations and that he has no power to implement his decisions or even to go back to the offending agencies and ask them to explain and review their positions. So if we keep the system that we have, we really must reinforce the commissioner.
So, in fact, how do we make sure that his powers become executory?
Well, in amending the act and creating those powers, and then there is always the possibility of judicial review by the federal court.
Okay. I'd like to hear you on the reinforcement of the linguistic clauses. You say that the language clauses are essential, and it prevents, just to make sure that the central agency overlooks, the Treasury Board overlooks that everything get implemented. But with regards to the linguistic clauses, what other amendments or how can we improve these clauses so that we ensure that, the government does assume leadership in this regard?
Well, I don't think it would be in the Act except for defining in a better way the supervisory role of different institutions like Treasury Board. In the present situation, it's Heritage Canada that is supposed to make sure that all the departments have a bilingualism plan and officers that supervise. But
Merci, Monsieur le Maître Bastarache.
Thank you, Mr. Bastarache. The time is up. I hope everybody can get their time, their 6 minutes, and perhaps we can come back to it. The next question is from the second Vice Chair of the committee, Mario Beaulieu. You have 6 minutes. Thank you, and thank you to our witnesses. My first question is to the Parliamentary Budget Officer, Mr. Giroux. You talked about $230 million for the private sector. You talked about bilingualism bonuses. I don't think that that's in the bill. So could you talk about that a little bit? Yes. What we have to consider here is that bilingual supervisors and those that aren't will be distinguished, and so there's going to be an effort to recruit bilingual employees. They will be therefore more in demand, and that will mean that their salaries will be increased. There will be a need for language training as well, and that will lead to bonuses. There is a lack of bilingual employees in the private sector where this legislation will apply. And those requirements will have to be met. Thank you. So you also said that there was a lack of cooperation with the departments. That doesn't really surprise me because I was looking into expenses and costs that were attributable to the Official Languages Act, and it was very difficult to get that information. In your opinion, what is the solution? Should there be a mechanism to ensure greater transparency? I think this information should be easily available. If not in the public domain, at least for parliamentarians like yourself who need to have this information. So it should be at your disposal. It was difficult. We had to get in touch with Canadian Heritage. We didn't always get answers. We had to go through more political channels. I want to change direction right now. Sometimes there are errors in the public accounts. For example, at certain years, there was some under the agreements between Canada and Quebec, there was an indication that the $600 million went to French schools, and then in other years there was no money attributed. So it wasn't clear what was being paid for by Quebec, by Ottawa. We had to go to the Quebec Education Department to look under the English education section to look at the transfers. In fact, there were transfers, but it was difficult to find the information, and it seemed that there were mistakes. And in some years where there were transfers, it wasn't indicated at the federal government. Have you had that problem? No, not to my knowledge. There are mistakes of that nature in the public accounts because the government takes a long time to make them public. So, for example, it's almost November. We still don't have the public accounts for the previous years. Sometimes it takes 3 or 4 months after the end of the fiscal year, which is almost 7 months behind us now. So really, there shouldn't be mistakes, given how much time it takes to put them together. So it doesn't happen frequently. Thank you. This wasn't in very recent years, I will just say. I want to have your opinion. The judicial appeals program, for example, we can't get much information about that. We can't find out how much has been spent in Quebec, for example, and yet that information should be available. We've got the FA who is here with us today, and for example, will we be able to get information about the funding and so on after the fact? Is it possible for taxpayers to know how their money has been spent? There certainly are strategic considerations regarding that program that are legitimate, but I think at least some of the information should be able to be made public, if not by province, at least by region. So knowing that some information could be harmful to certain groups, but it should be possible to provide some information so that parliamentarians can ensure that the tax funds have been used properly. That might be something for the Parliamentary Budget Officer to look into, because if we can't get that money, that information is problematic, because in Quebec we need to know how that funding is spent. Thank you.
Next question For 6 minutes, Ms. Ashton. Thank you very much for everyone. First question is for Mr. Giroux. In this committee, we talked about the underfunding for services offered to Francophones in minority situations well before C-13. For years, there has been a decline and a labor shortage in Francophone education outside Quebec. In your study on the financial impact of C-13, you said that the bill would only have a $2.9 million impact on the government. How do you explain this difference? Thank you for the question. The answer is a lot greater. So the costs for the government, for the federal government, for the administration of C-13 were estimated basing ourselves on similar programs that are not identical, but that are similar, by the federal government, notably by the CRTC. So the administration costs were included, and there's a discretionary power there. So the government could really go full throttle or balance things. It is really up to them. The other aspect of your question, well, I don't have the information regarding these underfunding or the level of funding in minority communities, linguistic minority communities, and so I can't comment on that. I appreciate your answer. Maybe I would like to highlight that the costs that you have already shared, and we know that that is limited to a specific aspect, is very minor compared to the government spending, especially knowing that there are significant demands across Canada for these communities. Another question. When you were at the Senate, you appeared at the Senate, no funds were included for the Justice Minister. Is this true? That is indeed my understanding of the funds that were allocated to the fall 21-22 update. Unless some information was not transmitted to us, that is how we see the current issue. Next question is for Maître Bastarache. Thank you for being with us. If no additional amount is allocated to having justice served in English and French, then what will happen? Do you think that this will be enough to improve the the offer of services in French? Well, what is spent provincially and federally is different. Federally, French services are only funded in federal courts. So the appeals court, the Supreme Court, and so on. In criminal law, there is an exception. You can ask to be tried in your own language throughout the whole of Canada, but only in the first instance. So we've always been told that there are not enough bilingual judges, but it's been at least 25 years that we've been doing linguistic training for judges, so it strikes me as quite unique. I, of course, have studied other countries where they have official languages, and I've never seen a country that you can have your trial done in your preferred language in the first instance and not also have that in the appeals court. That is indeed very preoccupying. Last question for Mr. Giroux. In your you estimated at the Senate that there might be 2 reasons why there is not enough funding in this bill. Among them, that ministers might have to make cuts elsewhere in order to implement the law. The government has failed with regards to its political or immigration policies. How do you look at this when it regards to African immigration? We'll have to. Your time is up, so we will have to answer it later. Next round of questions is 5 minutes each. Mr. Viss, new member of our committee, you next. Thank you. I would like to share my first minute with Mr. Godin. We heard the PBO earlier say that the ministers or departments did not collaborate and were providing information after he had published the information. So there seemed to be some delays, and that information is information. That is indeed important information. Mr. Giroux said that the information would be given to us as parliamentaries, and so I would like to propose a motion. The interpreter does not have the motion. I don't know if you can hear me, but I missed the second part. When does the second part start? You said something about Citizens and Immigration Canada, that with the study, the committee renew its invitation for the ministers from specific departments appear ahead in front of this committee. I'm sorry, for November 6th. Yes, I had heard October 6th. So the motion is clear. Are there any questions? I have an objection. I noticed that November 6th, that is a Sunday, so do we want to appear on a Sunday, and do we have the resources to do so? It's great that they want to work on a Sunday, but let's see if we do have the resources. Otherwise, we'll go to hell. Mr. Godin? Mr. Chair, let's correct this. October 6th was the date that we tabled the motion, and we are reactivating this invitation for these ministers and departments to appear as quickly as possible. So if I've understood correctly, we want to reiterate this motion from October 6th without indicating a date. Indeed, because I think that these departments will appear during the study and not afterwards. I think they're in good faith. So the motion is clear. Any questions? Mr. Chair, I just want to make sure, because we don't have anything written, Has it been sent to the clerk? Can we receive a copy? I just want to make sure. I just want to make sure that I have the motion in front of me. The clerk has the motion. Mr. Arsenault, your microphone. We'll let the team write this motion, but I think it's the same one as October 6th, but just reiterated. It's actually a different motion that takes some of the aspects of the one that was proposed on October 6th. Just an amendment, a friendly amendment. I want to congratulate their effort and for the bill to be presented to the House before Christmas, and we will second that. Let's present the bill to the House of Commons before Christmas. I just want to let everybody know my connection is not very good. I could hear everything, but the video is not going very well, so I'm going to reconnect. Mr. Godin, you wanted to add to Mr. Drouin's amendment? Yes, I want to amend the date for the deadline for the House of Commons. I've already always said that I want us to accelerate the process. At the Conservatives, we want to collaborate. We have mentioned many times we wanted to add sessions. That doesn't seem possible. We don't want to accelerate and cut corners for a historic bill. So I cannot accept the amendment that my colleague proposed. And my intention is to start before the holidays the analysis section by section. That is our intention, but I don't manage the time. We have a motion that after 20 sessions, we will reevaluate where we're at, and now we're at the 11th session. What you're saying, Mr. Godin, is not an amendment, but an objection to Mr. Drouin's amendment. Any other thoughts? Maybe it's best for me to just say it since no one can see me. I am also against this amendment, and we are also at the bloc in agreement that we should accelerate the process. I did what I had to do with the whips in order to make sure that if it's possible to even have more meetings. She told me that she had not received any such requests. So I don't think that the opposition is the one delaying the law. And I think that we do have to debate properly because in Quebec, none of these would have been adopted. None of these amendments would have been adopted. So, Mr. Beaulieu, you are against Ms. Ashton? Yes, quickly. For me, the amendment also doesn't make any sense. There's a lot of work to do before we head to the House. We have to do it efficiently, but we have to do it properly. With the requests we make with specific ministers, we make this request every time. And I wonder why the Liberals don't want to hear ministers as soon as possible. I would ask for a unanimous consent to remove my amendment, and so we can vote on Mr. Godin's motion, and then we can continue our work. I just saw a hand up. I just saw Mr. Iacono raise his hand, which I had not seen on the screen. Well, it's about my colleague who spoke about the presence of ministers. I did come to every single meeting, never from the government side was there ever any mention that we didn't want any ministers to appear. So I think that she should backtrack on her comments.
I have a point of order. Okay, I just want to hold off here a minute. I want to come back to the chronological order. Do we have unanimous consent for the withdrawal of the amendment? Yes. Yes. If the amendment is withdrawn, I will withdraw my point of order. I don't see anyone who is against, and I think we have unanimous consent in the room. Perhaps the clerk could confirm because I have a delay at my end. Thank you. Unanimous consent. So the amendment proposed by Mr. Drouin has been withdrawn by unanimous consent. Are we ready to vote on Mr. Godin's motion? Mr. Chairman, I think if you ask in the room, I think that there is unanimous consent here. Well, I will ask the question, is there consent to approve the motion of Mr. Godin? Yes, I confirm. I don't see any objections on screen. I have a little point of order. I hope that we will not be delaying the witnesses in the second hour because of this. Thank you for that suggestion, Mr. Beaulieu. We have 10 minutes, so there isn't a lot of time left. I think that the next time is Mr. Drouin? No, Mr. Chairman. My colleague shared his time, my new colleague, Mr. Vies, he shared his time with me, and I used 1 minute for that. Point of order. Mr. Chairman, I was speaking. I was interrupted by the point of order and then by the vote, and I didn't finish the point that I wanted to raise, so I would like to have the time to do so. Please go ahead. There was a comment to the effect that the government side did not want to have the ministers appear, and I just wanted it to be on the record that in every meeting I attended, it was never the case that our side did not want to have the ministers come before the committee. We agree. I have a point of order, Mr. Chairman. Mr. Chairman, I think, Mr. Godin, we will allow Mr. Iacono to finish his remarks. I just want to say that the government side would be happy to have the minister. I have a point of order, Mr. Chairman. The information that was provided by my colleague was said here. It was said that the Minister of Canadian Heritage did not want to appear, so I don't think that it is acceptable to hear from my colleague in that vein. Mr. Iacono. That information came from one person. I can't say if it's true or not, but I think we can't conclude on that. No, we should see what happened. I will not confirm that that was the case because I haven't spoken to the other party. So, for reasons of fair play, we have to confirm that that was the case. Thank you. Very good. We have less than 10 minutes left for the first witnesses. I'm going to have to shorten everyone's time, therefore. Mr. Godin, everyone can finish the second round. How we're going to do that in 5 minutes, I'm not quite sure, or 10 minutes. I will give 3 minutes, 2 minutes for your side, then 3 minutes. Well, Mr. Chairman, we are very cooperative, so please, let's do it that way. You have 2 minutes, 2.5. Thank you, Mr. Chairman, and thank you to our witnesses for being here this morning. I'm looking at this legislation from the context of the beautiful province of British Columbia. There are not too many people there that speak French. So, in your opinion, Mr. Bastarache, do you think that this bill will make it more difficult to choose a judge from British Columbia for the Supreme Court? Will it be more difficult to get a judge from BC on the Supreme Court? I believe that there are enough qualified people in every province to appoint a justice to the Supreme Court. Thank you. I have very little time. I'm sorry. Another issue for people in British Columbia with this legislation is the disconnect between theory and practice, because already the Official Languages Act is not applied in British Columbia. So is BC really ready to have the capacity needed to promote greater bilingualism? Are you asking me? Yes, Mr. Bastarache. The federal legislation does not apply to BC institutions, but only federal institutions in British Columbia. I don't believe that we have created a lot of additional obligations. We have only clarified the rights and tried to improve the system for the application of the Act. So I don't really see the problem there. Thank you, Mr. Vice. That's all the time that you have. We will now go to Mr. Drouin for 3 minutes. Please go ahead. Thank you very much. I want to thank the witnesses who are here with us as well, here in the room or on screen. My first question is for Mr. Bastarache. It is an honor for me to ask you a question regarding bilingual judges on the Supreme Court. We've had quite a bit of debate since 1988. In fact, I've been following this when it was decided that the legal community should be given an opportunity to learn the second language. It was decided at that time that it wasn't yet time to require Supreme Court justices to be bilingual. And then we had debate not long ago about whether it should be Parliament that decided on that. Do you think it is proper to have Section 16 applying to Supreme Court judges? Do you think it's constitutional? Yes, I certainly do. The Supreme Court of Canada was created after Confederation by federal legislation, and that is where the criteria come from. The Constitution simply says that there must be a Supreme Court. It was the 1982 Constitution Act and not the 1967 Act that defined those criteria. We need to take the vantage point of those who are appearing before the court, not that of the Supreme Court justices. Do all Canadian citizens who speak one or other of the official languages have equal access to justice if the Supreme Court justices can't hear them in their language. I was on the Supreme Court for 11 years. There were at least 2 judges who couldn't read the briefs or even any decisions in French before voting. They could only read documents that came after the decisions. So I found that totally unacceptable. So if we say that it should only be bilingual judges who hear cases in French, that isn't equality either, because there are groups on the Supreme Court bench that vote one way or another, sometimes for ideological reasons. So we need all Supreme Court justices to be able to hear all cases. Thank you, Mr. Drouin. Thank you, Mr. Bastarache. Please go ahead, Mr. Beaulieu, for 1.5 minutes. Well, very quickly, I thought it was a little bit insulting that you said that English is tolerated in Quebec. In fact, there isn't a comparison to be made between the situation in Quebec and elsewhere because of funding from the federal government. The UN Supreme Court Commission said in 1993 that a group can be the majority in a province but still be a minority overall. Canadian Anglophones cannot be considered an official language minority. That was the UN's point of view. We've got the federal government that provides money for court challenges by minority languages, and under the Official Languages Act, the actions taken benefit English advocacy groups and Anglophones. What is your opinion? I have never said that English was tolerated. I said that there was accommodation simply because the Quebec legislation indicates that there is one official language and it is the common language of Quebecers. The minister from Quebec has said that, and it was reiterated often by the premier in the last provincial election. What about the UN decision? Well, the UN decision has nothing to do with this. Thank you very much, Mr. Bastarache. 1.5 minutes for Ms. Ashton. Thank you. I want to come back to Mr. Giroux regarding my question from the last round. How can we explain that there is no additional funding to attract more Francophone immigrants, for example? Well, unfortunately, that question goes beyond the scope of the report and is really focused on the government's immigration policy. I haven't published a report on that recently, and I'm not the best positioned to indicate whether the government should spend more money to attract Francophone immigrants and what those investments might be. Understood. I would point out that that investment needs to be made. We're talking about $2.9 million, which is very minimal to implement this historic, significant change and update. We need to spend more money to attract Francophone immigrants to Canada. I think that this is I have 15 seconds left. I just wanted to thank our witnesses then and thank them for the good points they've raised. So those are That's the end of our 2 rounds of questions. I want to thank everyone and thank our witnesses, Mr. Bastarache, Mr. Giroux, and Ms. McCallishin. If you think there is any more information that you would like to provide her, if you provide us, and if you haven't had time to provide all of your answers fully, please send any more information to the clerk. We will just suspend for a moment to give us time to invite in the next set of witnesses. Thank you.
Resuming, a few things to note. Before speaking, please allow me to name you. There is a problem with the sound. We can't hear you. But I am there. It says that I am on the right one. I haven't done anything. So we are resuming. I was going to say, for our witnesses that are not accustomed, but before you speak, please wait for me to call your name. If you're since you are participating via video conference, click on the microphone icon to activate your microphone. Please mute yourself when you are not speaking. Regarding interpretation, for those on Zoom, you have a choice at the bottom of your screen between the floor, English, or French. Those in the room, you can use the earpiece and choose the desired channel. I remind you that all comments from members and witnesses should be directed to the chair. And for our witnesses, you each have 5 minutes, but it's a strict 5 minutes to do your presentation. If you have additional things to add, you can do that during the question period. So first, Mr. Maître Taillon, co-director, professor and associate director of the Center for Constitutional and Administrative Law Studies, Faculty of Law at Université de Laval. We also have the Association Canadienne Française de l'Alberta, or ACFA, Pierre Asselin, the president, and Isabelle Lorrain, the executive director. You each have 5 minutes to make your presentations, and we will start with Maître Taillon. Thank you, Mr. Chairman, to the members of this committee for the invitation. The federal government is doing a great deal, indeed a great deal, to protect and promote French and its institutions. The heart of my point here today is not to criticize the amount of effort that has been made, but what I want to emphasize is the importance of reorienting the goals. The reality is that the federal government is a very poor partner in practice and is far from cooperative federalism in terms of language matters. It hasn't taken into consideration the fragility of French when it is in a minority situation in Quebec and the decline where it is declining. So Bill C-13 aims to correct this problem, but I'm afraid that the solutions put forward here are not rigorous enough. By definition, federalism implies inevitably the coexistence of several regimes, several language policies, and therefore a duty to cooperate. In the case of Canada, even the Constitution, the supreme law, and common law of all federal and federated entities provides for asymmetrical regimes and obligations in the area of language. As the text of the Constitution Act from 1867 explicitly states, in Section 90.Q2, Quebec is the only province and the only jurisdiction in North America to have as an official and common language French. The only place where French, although in decline, remains is in a majority situation. So, of course, Quebec also has constitutional obligations to Quebec's historic English-speaking minority. And we have to reassure this minority. Neither the Official Languages Act nor the Charter of the French language can change the rights that are guaranteed in the Constitution with regards to the English-speaking minority. The issue is that of the compatibility of the linguistic regimes. We must learn to harmonize, combine, and add efforts and ensure that the federal government can contribute to protecting French in Quebec. We must stop placing Quebec in a situation where it must choose between defending its interests and those of francophones and minority situations elsewhere in Canada. We don't want a federal policy that antagonizes and divides or pits communities against one another. Bill C-13 attempts to correct the situation, but I'm afraid that the operation is too timid. And in the few seconds that are left, I'd like to highlight 4 solutions. First, beyond the preamble, it is necessary to include an interpretive provision and definition for the criteria for statutory delegated authority. We must reiterate the recognition, the explicit recognition of the objective of substantive equality, the different situations, for example, and also reiterate the intention of the federal legislator to halt the decline of French. Less than 30 seconds. Second, with regards to the integration and francization of immigrants, Canada rightly imposes tests of knowledge and mastery of one of the official languages prior to obtaining citizenship, which is very good. But by leaving new Canadians a choice between knowing French or English, it neutralizes and harms Quebec's efforts. And so we have to adapt it to the Quebec's needs. Mr. Taillon, I will let you elaborate later during the question period. My apologies. So, on with ACFA. Thank you. My name is Pierre Asselin, and I'm the president of the Association Canadienne-Française de l'Alberta, ACFA. I am accompanied by our executive director, Isabelle Lorrain. Thank you for the invitation to appear before you today. Your work is invaluable to the future of French in Alberta and elsewhere in the country. And the modernization of the Official Languages Act is a key issue to ensure its success. Since 1926, the ACFA has been defending the gains of Alberta's Francophone community, advancing its rights and enhancing its vitality. The ACFA represents more than 261,000 French-speaking Albertans, a population that has grown by more than 50% between 1991 and 2021. Despite this success in Alberta, due in large part to a booming economy in recent years, there's a decline in the Francophone population in Canada. The 2021 census data clearly shows this. This is why the modernized Official Languages Act must be adopted without further delay. There is an urgent need to act. I don't want the next generation to be sitting here having the same conversation. As a member of the Fédération des communautés francophones et acadiennes du Canada, the FCFA, the ACFA supports the main thrust of Bill C-13 and reiterates its support for the improvements proposed by the Federation. In recent months, the FCFA and its members have had numerous meetings with parliamentarians and have expressed their wishes for improvements. I would like to take advantage of my presence here to come back to 2 elements of improvement that are essential from our point of view, namely the addition of language clauses, and 2, the need for clarification of the Francophone immigration policy. First, with respect to language clauses, when the federal government proposes new funding for specific initiatives, take, for example, the recent November 2021 agreement for $10 a day childcare, there's no formal mechanism to ensure that funds are also allocated to Francophone communities. We are therefore dependent on the goodwill of the provincial governments, and we must invest a lot of human and financial resources to make the necessary representation. We would therefore like to see the addition of an obligation to include language clauses in federal, provincial, territorial transfer agreements, while specifying that the federal government may consider the option of dealing directly with Francophone communities if a province or a territory refuses a language clause. This is very important in Alberta. This option of dealing directly with the communities would address the fact that the federal legislation cannot bind the provinces to such language clauses. Second, with respect to Francophone immigration, we would like to see clarification that the new Francophone immigration policy should not only contribute to maintaining or increasing the demographic weight, but that it should have as a specific objective the restoration and increase of the weight of the Francophone population in Canada. We are talking here about recovery rather than maintenance. An FCFA study shows a need for remedial targets in Francophone immigration to address the demographic time decline of the Francophonie. These two changes would make a huge difference in the daily lives of French-speaking Albertans by addressing the decline in demographic weight and ensuring access to provincial services in French. These are critical to ensuring the vitality of our communities and countering assimilation. ACFA, or ACFA, has been working on this issue for nearly 6 years. It was on December 8, 2016, as part of the consultations for the 2018-2023 Action Plan on Official Languages, a plan that is coming to an end, that the Minister of Official Languages at the time, the Honourable Mélanie Joly, asked our President, Mr. Jean Johnson, what she could do to have a major impact. He dared to propose the modernization of the Official Languages Act. She personally invited him to share this idea in front of a packed room, which was ecstatic, of course, to do. Since then, for the ACFA alone, in addition to Jean Johnson, the message has been carried by Albert Nollet, then Marc Arnal, Sheila Risbud, the following president, and now myself, Pierre Asselin. Less than 30 seconds. In the meantime, there have been several studies and reports in parliamentary and Senate committees, commitments from all political parties, a reform document, and 2 bills. But here we are still discussing modernization and what the Francophone minority communities would like to see in the bill. We have been talking about this for over 2,000 days and presenting our dreams, our aspirations, and our needs. It is time to put an end to the delays. With all due respect, it is time for our elected officials to act.
Thank you very much. You'll have a chance to add additional comments during our question period. We will start the first round, 6 minutes for each member that speaks, each party. And I have to be very strict with the time because we need everyone to be able to prepare the questions that they have prepared, or to ask the questions that they've prepared. So we will start with the first Vice Chair of the committee, that is Mr. Godin from the Conservative Party. Thank you very much. We need to try to make Bill C-13 better. That is our job. I will start with Mr. Taillon. Can you tell me whether or not Bill C-13 meets the 3 objectives that the Conservative Party has? That is, stop the decline, promote both official languages, but with the understanding that the most fragile language is French. So does Bill C-13 meet those objectives? Well, meet the objectives, that will only be possible to assess in a few years. But to name the issues and to say clearly that French is in decline in Quebec and that this is something that was not in the legislation before. So that can be seen as part of the solution and not part of the problem. So the first of my 4 proposed solutions was to put some information in a preamble, which is not really part of the act, but actually helps the courts and others interpret the legislation better. Some people claim that because the wording is in the preamble, it isn't really in the substance of the act. But in fact, if it is in an interpretative clause, then that can help define the powers that are held or delegated by the federal government. So this is a change. Thank you very much. So if I'm to understand correctly, it doesn't meet the objectives very effectively. It could be better. That's what we're working on. In the preamble, that isn't strong enough. Can you say that it is about the same as putting something in regulations? No. If there is uncertainty, then a preamble can have an effect. For example, when it comes to the Constitution Act, the preamble has been very important, as in Britain. Yes, thank you. I will ask you a question. So you're saying that a preamble and regulations aren't the same. It doesn't have the same role in enforcing the legislation. But can a preamble be or can regulations be changed easily? Can they reflect the changing ideas of the government? Yes, they can be changed quickly. When it comes to delegating powers, then there needs to be wording that helps define the criteria. If it's in the preamble, it can be very useful for that purposes. So that's why, Mr. Tayo, we want to take the time needed to make a good bill, even if we have to take extra time to do that, so that governments that will follow us and that are affected will be able to protect against the decline of French. So we are calling on the current government to use what the current government is saying is that, well, we'll just take what we have and then we'll make the improvements in regulations. But we don't agree with that. My next question is for Mr. Asselin. You said in your remarks that it is urgent for us to act, that it has been 2,000 days, that is, since the government was elected. So what do you mean by urgent? Are you talking about a week or 6 months or a year? What are you talking about in terms of time? We've been talking about this since 2016, and my intention is for it not to continue so that the next generation has to deal with these same issues. It is time to pass this legislation. We've been dealing with it for a year. That's much too long. Even if it isn't perfect, let's adopt it. So your desire is for us to adopt this legislation and we'll correct it as we go along. No? What are you saying exactly? There are important points for the Federation, and those could be corrected so that we can go forward. Well, is it a clear condition when we talk about having the Treasury Board Secretariat to be the core agency for making the decisions? That is an absolute condition for you to change that? It's really the issue of the linguistic clauses. So that is your bottom line, but the agency is less important. Your bottom line is the linguistic clauses. Thank you very much. Mr. Godin, you can perhaps go into that more later. We will now go to Mr. Iacono for 6 minutes, please. Thank you, Mr. Chairman. I want to thank our witnesses for being with us today. I will start with Mr. Taillon. The protection of linguistic minorities and the protection of French have always been a priority for our government since we were elected. And we are strongly opposed to the idea of funding the French. Rather, we are very interested in the issue of funding for the French University in Ontario and, of course, in New Brunswick as well. Can you tell us whether Quebec's intention to have enshrined in the Constitution that it is French jurisdiction with only one language, does that not threaten the situation of francophones in New Brunswick and elsewhere in Canada? If New Brunswick decided to do the same thing tomorrow and said that the only official language is English and that no public service could be provided in another language, how do you see protection of francophones under the Constitution and the Canadian Charter of Rights being carried out? I will be happy to answer the question, but I think there are assumptions that are wrong in the question. Neither Quebec nor New Brunswick have the power. The provinces cannot change the Constitution Act of 1867. Quebec can pass its own legislation, but there are intangible guaranteed rights for Anglophones under the Constitution Act. But how can they do that? It's guaranteed under the 1982 Constitution Act. There are 5 procedures that enable changes to the Constitution Act, and different players are involved. There are guarantees for bilingualism in I think it's in a particular section of the 1982 Constitution Act that provides guarantees. For example, for Anglophones in Quebec under Section 123. So Quebec does have the ability to make certain changes that affect the Constitution, but it can't erase guaranteed rights. So if you say that Quebec, or the fact that Quebec has decided to adopt one official language, French, that can raise concerns. But it is taking into account certain rights that are guaranteed under the Constitution. So there has to be harmonization between those rights. Thank you. My next question is for Ms. Laurent or Mr. Asselin. How will the bill C-13 and the next action plan, the roadmap, how will they benefit francophones in your province? Thank you for that question. I think that will depend on whether the linguistic clauses are included in Bill C-13. They are extremely important for the situation in Alberta, given the history. We need restorative clauses, and if that happens, then we will see an incredible impact of these updates. Thank you. Ms. Laurent, or for Mr. Asselin, you can decide between yourselves. How can the government provide better protection and promotion of French in places like Alberta, where French is a minority language? Well, as I've said, the linguistic clauses are extremely important for young children, services for young children, for the health services, education. We need those services, and we need a different approach that will ensure that Albertans that don't have support from the province will have funding and help from the federal government.
Does Bill C-13 need to include linguistic clauses? Absolutely, it should. And we have submitted that request, as has the FCFA. Thank you. 6 minutes, Mr. Beaulieu. Thank you to our witnesses. Mr. Taillon, you weren't able to finish your presentation. There were 4 points. I'd like to give you the opportunity to finish. Well, the first point, I spoke to Mr. Godin about it. The willingness is in the preamble, but it should be included elsewhere. And then secondly, there is the issue about the integration and welcoming and Francization of immigrants. There is the requirement of a linguistic test, which is a good thing. Should that not also be mandatory in Quebec in order to halt the decline of French? And also maybe have Quebec that can actually follow the beat of the rest of Canada with regards to welcoming immigrants. Then there is also the federal power of spending. Sometimes that can be seen as intrusive by other provinces. If we want to be cooperative with Quebec, we do need a federal-provincial agreement on that aspect of being able to spend on official languages. And maybe one day we'd be able to have the right of removing ourselves with compensation. We have to be aware of the impact of linguistic clauses on the Quebec, in Quebec. By imposing linguistic clauses without any framework, without an agreement between Quebec and Ottawa, then the federal government finds itself imposing on private businesses a standard of bilingualism that is actually against the policy of having French as a common and official language. So we do have to be more balanced here. But this bill has, when you consider giving businesses the choice, I think there's a little bit of hypocrisy there. It's like we don't want to really be fully consistent, and I think that that's, fooling ourselves. But we can resume. That essentially is how we resume the 4 points. Quickly, the Official Languages Act in Quebec really helps to reinforce English. We fund the Anglophone education system, for example. The Legal Challenge is also funded because they are allowed to legally challenge certain things. In 1993, the UN said, and I will quote, that a group can be majority in a province but still a minority within the state and therefore be protected by Article 27 or Section 27 that protects minorities. Canadian English, Anglophone Canadians cannot be considered a minority, a linguistic minority. In light of that, do you think that we can modify the definition in order to recognize the specifics that French is actually minority language in Quebec? Well, the important thing for me is to recognize that Anglophones in Quebec are in a radically different situation than francophones outside of Quebec. The Quebec government has always respected its word with regards to excellent quality of services. So we do need a cooperation, because if we do have the same goals, so yes, respecting certain privileges and rights for the Anglophone community, but also halting the decline of French as a majority in a majority situation in Quebec, that's something that we never had before. We had a law for languages that are in minority situations, but sometimes that was something that actually hurt French in Quebec. But when we recognize that there's a value, that we think that there is a certain value to the fact that there is a majority French Quebec and that it is actually declining, then we can have a different policy. But it really has to be reflected in the rest of the bill, in the agreements, and also in how money is spent in Quebec. Sometimes it goes against the spirit of the Constitution. The idea is good, but we really have to be coherent, because the objectives do converge. And if that is the case, then we have to take into consideration the consequences. I don't have much time left, so thank you. I can't say much in 10 seconds. So, Ms. Ashton from Manitoba. Oh, apologies. Thank you. I had a technical issue. Thank you to our witnesses. First question for Mr. Asselin. You highlighted the importance of linguistic clauses. You used as an example the agreement on daycares. Can you briefly share the reality in Alberta? I have already shared my personal situation here in Manitoba, where we were unable to send our children to daycare in French. Yes, we have the building, but we don't have a labor shortage. There were a lot of issues because we weren't able to bring in immigrants from elsewhere. And even with our help, we are aware of the waiting lists and the big demand here in Manitoba. And of course, the lack of support is very worrying and concerning. Can you tell us a little bit about the situation in Alberta with regards to early childhood education? The population has increased by 50% in the few years, and so that continuum is worrying for us. If it doesn't work for the early childhood daycares, that is concerning. Manitoba, well, they're very strict. They resist a lot. They did make a change recently for the daycares. It took a long time. But the point that I'm trying to make is the following, is that the services are lacking here in French. So if we can't access daycares, then we will lose our schools. So if we could do more, that would be great. But same with the daycares. We do have an agreement with the province, with other sectors, healthcare. We can do that. We can deal directly with the organization. So with Alberta, we wouldn't be in a worse situation, because right now they're not accepting the conditions. We do need these services if we want to continue on as a community. Thank you. And very aware of the difficult situation at the Saint Jean campus in Alberta. My question is, with what we know about the new Albertan government, how urgent is it to have investments into community organizations like yours? It's urgent, and I'll tell you why. We talked about a parliamentary secretary of the Francophonie that has been implemented in 2019 in order to help French. Our organization helped at that stage. It's urgent to do it now because the situation in Alberta is not improving. It's very preoccupying. As always, you have our support. We need to support the campus, the Saint Jean campus, and other campuses, francophone campuses outside of Quebec, especially in Acadie, so that they can continue the work that they're doing. Question for Mr. Taillon. We talked about the importance of territorial approach so that we can protect the vitality of languages in a minority situation. How do you think that that should be reflected in a bill? Well, this is a possible tool. What's important for me is that communities, both national or linguistic, are not all put in the same situation. We need asymmetrical approaches so that we can aim for a more equal reality. The minority situation francophone communities outside of Quebec need more support. There is more support now. With regards to Quebec, we need to ensure the flourishing of French. So we are in very different situations, and I don't have enough time, but sometimes we need to adapt our approach in order to reach our goals. And so I think we need to focus on the goals in order for them to be reflected, and we need to adapt to them. And then we can use whatever tools that are at our disposition to achieve those goals. Second round of questions. 5 minutes each, starting with Mr. Dalton. Thank you to the witnesses. Mr. Taillon, what are the demands in Quebec that are absolutely essential? Thank you for your question. Well, I found out about this work, and I'm very much in agreement with all these amendments. I know that you have a very specific deadline, but there is a bit of repetition with some of the amendments. But they are all important. It's the will that is in the preamble that needs to be reflected elsewhere every time there is an amendment and so on. So if we categorize those amendments, a lot of them would, you would see that a lot of them tend to just want the federal government to reflect that throughout the bill. And so halting the decline of French in Quebec, and recognize that this is, that French is very important in Canada, and recognize that Quebec is a francophone province that respects Anglophones' rights. Another thing that's important is that, yes, the government can have administrative agreements between Quebec and Ontario, but why not have a legislator that says, yes, indeed, it does have to come to agreements, and yes, we want to cooperate and do so in a way that applying linguistic laws in Quebec will not be perfectly symmetrical to what is happening, how we do it in the rest of Canada. So it's a huge amount of work. We have to really make sure that they are grouped around the goals. You know, linguistic clauses in Quebec and so on. That falls under the cooperative side of things. And so that we have to say that, of course, the federal government also wants to help halt the decline of French. And can we impose linguistic clauses in Quebec? And Maître Bastarache was not in agreement. What do you think? Well, I will be careful to not interpret what Maître Bastarache said, but it's a difficult issue. There's a certain culture that is associated to the former Official Languages Act. We don't want it to match them up with the Quebec policy. And what we're saying is supporting, the federal government says we want to support minority groups, and that's it. But that actually antagonizes both the policies. And so maybe it'll take some time before everybody gets used to this new act. But I am really, not in agreement with the former approach, and we need to adopt this new approach, and it has to be reflected in all administrative agreements. Are Quebec's demands compatible with Francophone communities outside of Quebec? Well, that was the issue with the previous act. It created a dynamic where, well, in fact, Quebec was not working in solidarity with other Francophone minority communities. The objective is that we need to have a better marriage between them, especially that offers a possibility. We don't want rivalry between the two. By helping outside of Quebec communities.
Merci, Maître Taillon.
Thank you, Mr. Taillon. Thank you, Mr. Danton. Next questions. Ms. Kaya-Baga, you have the floor. Thank you, Mr. Chair. Once again, I'd like to thank our witnesses for being with us this morning, and I'd like to thank all those who've spoken to this bill. I'd like to put my question to Mr. Asselin. You mentioned the speed at which this bill should move forward. I'd like to hear you on this once again. We know that the communities that are in a situation of linguistic minority are really impacted by this decline of French across Canada. And the longer we wait, the more this impact will deepen. Could you tell us more about this? Thank you, Madam, for your question. I fully agree. At one point, you have to figure that this decline that goes on by delaying the adoption of this bill will be greater than the gains we will make. So we've reached this point. I mean, we mentioned this in 2016. I mean, enough. The time has come to move forward. And I believe that we should leave well enough alone. Now, as part of C13, to what extent the representation of our two official languages should be could be hindered. It was well detailed by Mr. Taillon. The difference that we have in this bill is the recognition that there is a goal to put an end to the decline of French. And by adopting this change in the approach, we'll have a different approach and versus the former bill. And yes, we have a national committee, but if we update this goal, I mean, we want to put an end to the decline of French. How do you see this modernization of the Official Languages Act, and how can it improve the protection of French in a situation for people who are a part of the linguistic minority? I mean, we have to have this approach of having more Francophone immigrants so that we can support the Francophone minority in Alberta. We need a restorative approach. We've been waiting for 7 years, and we have done nothing. And this is approach we see in this bill and that we feel is exciting. Now, if I go back to the impact, I mean, the more we talk about it, already in C13, we'd have an opportunity to be able to re-examine this bill every 10 years. You've raised a few points you would like to see amended in this bill. Do you think that we could work to move forward, or do we have to simply take stock of all the points raised in regards to this bill, or is there space within this bill that we can change while we continue with the implementation of Bill C13? Yes, we can amend as we go on. We cannot wait for things to be perfect. It's been 7 years, and I wouldn't want my son to be here 10 years from now. It's important that people who are on the ground now and who are being assimilated. It's wonderful to have a plan to say, okay, we'll catch up, but the situation should be addressed now. And it's useless to tell people who are now being assimilated, tell them the problem will be resolved later. I share your opinion. And since I am in a community that is in a linguistic minority, I fully understand what you're saying. So we mustn't stop. We must go on to ensure that our communities are well served and that we keep our French language in our communities. Any law would be imperfect to a certain extent. And we have one goal in mind and put an end to assimilation, and time is not on our side. Mr. Asselin, if you have more to say in the 15 seconds that are left, I'll give you the floor. The PLOI program is a mechanism through which the federal department can help the education continuum in Alberta, and especially the Saint-Jean campus. Thank you. Next question, 2 minutes, 30 seconds. Mr. Beaulieu, you have the floor. Thank you so much. On the one hand, a question to Mr. Taillon. You said you agreed with the overall amendments of request of amendments of the government of Quebec. Nothing. There's none of those amendments appear in what we're doing in terms of C13. Now, should we take enough time to meet all the requests of the government of Quebec that amount to 90% of the Francophones in Canada? My fear is that, rightly so, the government took an important shift and did a mea culpa in terms of the former decades. But my fear is that by keeping this message in the preamble, which is basically a blank check to the by having a mechanism where many things take place at the government level through regulations, and my fear is that we end up with a willingness to change that is too soft and that could come across resistance elsewhere. So it's important to take the time to make everything official as part of the very mechanism of the law. It's just as if we were trying to find a way out. And I understand the government needs flexibility, that courts needs to have some leeway, but it is also the role of the legislature to have a willingness and a will that is as clear as possible. Because let us not delude ourselves, the ability of the government, of the legislature, of public authorities to put an end to this decline is limited. And if it goes through a soft willingness, well, the likelihood of getting to our goal is even lower. Less than 20 seconds, Mr. Beaulieu. Making French the common language is crucial to be able to integrate. We have to make sure that our allophones, at least 90% of our allophones, learn French and speak French. Now, 2.5 minutes, Ms. Ashton, you have the floor. Last question, but not least. Thank you. And my question would be for Mr. Asselin, once again. I'd like to see what impact could the systemic refusal of the federal government to welcome foreign students in Canada and the future of the on French. Thank you for your question, Ms. Ashton. We are very much concerned. We find it very disappointing what's happening. There's a shortage of labor, and it's through immigration that our community can thrive. It is important to maintain services for people who are here so that we could put an end to assimilation. But this absence of targets, this absence of any restorative approach, we've wasted 20 years, and we're suffering from this. It is important that we take on this restorative approach. The community in Alberta has changed tremendously over the last 20 years. There are many Francophones from Africa that have enriched our community, and it is diversity that everyone in our province appreciates. It's a huge source of manpower in our province, and we're disappointed with the current situation. Thank you so much for your question. Thank you for having shared this with us. It is a message we have heard across Canada as well, and it is very much concerning. We have an opportunity through C-13 and through these substantive amendments to start to correct this situation. I only have a short period of time left. I'd like to ask Mr. Salan, 30 seconds. Mr. Taillon, Mr. Asselin, very briefly, your last messages for the committee. Very briefly, now is the time to act. We are asking the elected officials to act and adopting a bill. Any bill is imperfect. We'll strive to improve it with time, but we have to put an end to this decline as quickly as possible. It's an important file that requires the attention of the legislature, and we have to set obligations. The legislature must impose obligations to the government. There are limits to delegation of powers, etc. Thank you, Mr. Taillon. Thank you to our witnesses for having made yourselves available for this committee. Thank you for answering the questions that were put to you. If you felt you didn't have enough time to answer some of the questions, if you feel there's additional information we could benefit from as a committee, please forward this whenever you can as quickly as possible to our clerk, and she will share it with all our members. Thank you so much for your time. It was extremely important for us to hear you out. Mr. Asselin, Madame Laurent, Maître Taillon, who is about to take a plane, thank you once again. We will not adjourn, but suspend the hearing so that we can go in camera. For the members who are assisting virtually, you have to change the Zoom address. Thank you, and we're now declare this meeting.